Now, second presentation, James McKay on new developments in property law. James is a guy who's come to the bar in the last couple of years after working in practice for a couple of years before that. He has a commercial practice with a significant part of which is in the area of property law. He regularly appears in property law matters and advises in property law matters, and is going to talk to us about new developments. James McKay.
Thanks very much, Michael. When I first discussed the topic of this paper with Michael Green, he said to me, "New developments in property, have there been any?" This quizzical look on his face, and I think it's quite a good comment. It's obviously an area that's the basic principles of which have been mapped out and defined for some time now, probably since the late 19th century. Things have been more or less, in terms of common law and equity, perhaps also the way we see them today. If anything, the main change or the main driving force behind change is coming from legislation, and particularly consumer protection legislation. It's obviously designed to protect mainly the tenant in retail leasing contexts, and also the members or the weaker party in owners' corporation situations. And you can see that kind of trend existing all the way across the commercial law and all the way across property law. You'll see also that theme arising very much in this paper that I'm delivering today, as well as you saw it arise, I think, in the paper that Sam's just delivered there. I think the questions that were raised there at the end as well were both very telling in terms of the kind of problems that this new legislation is throwing up. We've had the question there about the franchisor being in a very difficult situation trying to get the new disclosure statement from the landlord, and I think the answer to that is, can anyone think of one? I just do not, unless there's something actually expressly in the Act that deals with it and puts an obligation on a landlord to provide that document, then one has difficulty understanding what the basis could be to force the landlord's hand. And that's an example of the kind of anomaly, if you like, that pops up in these situations due to these legislative changes. The other situation as well, where you have a lease that's expired, absolutely with no renewals left, and then somehow it's now illegal based on the key money, or potentially illegal based on the key money provision, for a landlord to say something like, "Look, I'll give you a new lease. I'm not obliged to do so, but if I do give you the new lease, then you're not to make a claim based on that old grievance you had from way back when." It seems a very drastic interference by the legislature, if indeed the key money provision does apply, in terms of people's freedom to bargain amongst themselves. And certainly it's a very interesting problem that's only now just coming about due to perhaps the ambiguity of the key money provisions. So to continue though, my paper will deal with the same kind of issues, and generally the themes or the areas I'll be examining, particularly first, is misleading and deceptive conduct. I think the fusion really between that area and consumer protection generally is something that's incredibly important for property lawyers these days, and I'm sure most of you, or at least some of you, have also a litigation background as well, and property law will be a significant part of that litigation practice, but you'll need also to understand broader doctrines and will be interested in doing so for your broader litigation practice. So we'll be examining that. Also, there'll just be some general discussion of some of the provisions of the Retail Leases Act that Sam's touched upon, and other statutes such as the Owners Corporation Act and things like that. First of all though, I wanted to just touch on the decision of Umbers and Kelson, which really mainly for interest. It's an incredibly interesting decision, and one where there's got to be a real question, I think, as to whether it's been correctly decided, which is always one of those fascinating things when we can all have a think about it and have our own view about whether these esteemed members of the judiciary have perhaps got this one right, or whether a non-specific expertise in property law has perhaps caused them to see the problem in a way that most of us would not, and therefore to come out with an unusual decision. This case, of course, you've probably at least seen it at first instance when it came before the Supreme Court. It's now been fairly recently pronounced upon by the Court of Appeal in a decision of Justices Hanson, Redlich and Neve. It relates to the subject to finance clause that's now in the standard prescribed contract, and it's specifically, it was a sale of business problem, but it's the same finance clause that's in the current prescribed contract and was in the Table A conditions before that. What happened was it's a standard situation where you're coming to the end of the finance expiry period, and the purchaser is interested, of course, in obtaining an extension so that they can keep the contract on foot but then not expose themselves to some kind of risk that they won't be able to actually get the finance. So the standard letter is then written, or what I would consider to be, in normal conveyancing circles, a fairly standard letter that said, our client has not had finance approved at this stage. We seek an extension of 1 month to the 17th of August 2005. In the event that an extension is not agreed to, you may treat this letter as written notice ending the contract. And of course that was given 1 day before the expiry, so it was quite obvious the context in which it was given. And what I'd suggest to you is it's quite obvious what its meaning was, or at least the intended meaning was from the writer. Of course, the relevant finance clause, I should read it, it says the right of termination applies only if the purchaser serves written notice ending the contract on the vendor on or before 2 business days after the approval date. And so this was 1 day before the approval date, so there's still a couple of days left to run. Now, the Court of Appeal found that that letter was fatally ambiguous, and the ambiguity was said to lie in the fact that all these concluding words where it says, in the event that an extension is not agreed to, you may treat this letter as written notice ending the contract. And the objection taken to that wording was that it seemed to vest a discretion in the vendor to decide how they wanted to treat the situation, whether they wanted the contract to come to an end or whether they wanted it to continue, which is obviously a highly unusual construction to place upon the letter, one would have thought, when the whole point obviously from the side of the purchaser and his lawyer was to protect his own position rather than vest some kind of right in the vendor. At first instance, it's interesting to note that this point about the word may and the construction of the letter was never in fact argued. So we had barristers and a magistrate hearing this decision, or this case at first instance, and the whole trial was run on the basis that this termination letter was entirely valid. So nobody obviously thought there was any confusion about it on the ground, so to speak. And the case was decided by the magistrate in favour of the vendor on the basis of an estoppel, which I won't go into the circumstances of that estoppel, but the argument presupposed that this letter was valid and that the contract had come to an end. In the Supreme Court, there was argument also on the estoppel point and various things that were not really relevant to this point. And then after the hearing had taken place, the associate of the Supreme Court Justice wrote to the parties or contacted them and said, I want to hear further submissions about this point because I'm not certain that this letter has actually brought the contract to an end successfully. And so the parties came back and made submissions, and the finding of the Supreme Court was more or less in line with the finding that ultimately prevailed in the Court of Appeal, which was that, I'll read the concluding line, the purchaser tried to have his cake and eat it. The letter did not end the contract, and so the contract remained on foot. And then also the letter was an approach by the purchaser to the vendors to seek an extension of the finance approval clause, and in terms left the vendors the option to accept the letter as a notice terminating the contracts if the vendors wished to do so. So we have that notion of the vendors having the discretion as to how to treat the letter that was sent. As I said, the same conclusion was reached by the Court of Appeal, which obviously in the context is a surprising one. I think the only explanation we can find for this kind of determination was perhaps a throwback to this idea that it's the sort of strict wording of a document that matters and not the intention that might be behind it or so much the context. And of course, when you're construing a written deed of agreement or something like that, that might be a valid and indeed an orthodox way to approach things. But of course, in this context, the contract itself said that all that needs to occur to end the deal is that written notice is given ending the contract. So of course that brings into play not only objective notions about how the letter was worded, but of course also subjective ideas about how the parties actually treated the communication that passed between them. It seems quite remarkable in my submission that the parties this was raised on the first time by an appellate judge when the parties had quite clearly treated the letter amongst themselves as being a clear communication by one person to another that they wanted to end the bargain. So there's some cases set out in the paper there that deal with the general issue of sort of objective views about rescission notices and things of that nature, which are very useful because, of course, this area is closely related to the idea of the 14-day rescission notice that's served under the prescribed contract of sale. And of course, there's plenty of case law that deals with the defects that might arise in that notice. And there's very much an objective view that prevails in that case law that treats the wording as the be-all and end-all rather than any kind of intention or understanding between the parties. So that seems to have transposed over to this kind of context. But anyway, it's a very interesting decision and one that I think will continue to elicit discussion and perhaps some controversy, but the outcome is clear and it's very simple. I think that the only safe way now is to not use any kind of conditional letter to try and end or to try and get an extension in these circumstances. If you're faced with a deadline on an expiry clause or a finance clause looming, then the way to do it is to send 2 letters and give the warning that you haven't got the finance and then obviously follow it up with an independent letter. I think that the problem perhaps with trying to do a conditional letter, even if it's properly worded, is that it doesn't satisfy the criterion in the contract, which is a written notice ending the agreement. Because if you're doing something that says, I may terminate or I may not, depending on things that transpire in the next couple of days, then by definition, what you have sent does not fit that criterion. So that was the difficulty faced here. Now, the next case I'll deal with quickly. It's something that I'm sure most of you are familiar with, but it's so important to mention its fundamental point that just due to the practical effects of not knowing about the decision and not knowing how to draw your contracts of sale to cater for it. The decision Solid Investments Australia Proprietary Limited and Clifford, which is also a decision of the Supreme Court of Appeal. The case, of course, concerned off-the-plan contracts, and we're all familiar with the previous way of drafting those contracts where there'd be an approval date specified for registration of the plan of subdivision, and then the developer would be given a right under one of those gigantic clauses that allowed them to extend the date at their discretion based on pretty much anything you can imagine, inclement weather, strikes, all those kind of things, delays in building. So really you had these contracts that, and it was of course part of the course. I don't think I saw a contract prepared by any sort of firm of repute that would draw these contracts without putting something of that nature in there. So we had these infinite contracts, you might call them. Now, in this case, we had a purchaser that was courageous enough to challenge that mechanism, and in doing so, they relied on, there's a couple of purchases, they relied on Section 9AE2 of the Sale of Land Act, which says, if the plan of subdivision is not registered within 18 months after the date of the prescribed contract of sale, etc., or if the contract specifies another period before the end of that specified period, the purchaser may, it goes on, but generally rescind the contract. So the critical words are, or if the contract specifies another period. Does this mechanism that we saw so often in the past specify another period, or is it really just an ambiguous thing that relies on discretions and contingencies that are not known at the time the contract is entered into? Both at first instance and at the Court of Appeal, the argument or the finding was that it is too ambiguous and too contingent to meet the statutory criteria, and that the way now these clauses are drafted, of course, is to have a fixed period, or at least something that, if it's based on any kind of external event, it's got to be an event the day of which is absolutely certain. So the key is, do not, if you are still doing it, draw the contract in that way so the registration date is extendable based on all these ambiguous factors. You must choose a registration approval date and stick to it, or have one that can change or flux only in accordance with absolutely certain criteria. Of course, as well, if you have a contract that, because these things are long-term affairs, you may have, if you're not familiar with this case, a situation where you're trying to get out of a contract and the contract was drawn before the first instance decision when everyone realised this potential deficiency. It sort of became, or it came quite out of left field, I think. Nobody really spotted the weakness in these contracts or the potential argument arising from Section 9AE. Otherwise, of course, all the big firms wouldn't have drawn the clause in that way. And so you can still catch people out and make use of these provisions as a litigator acting on behalf of a purchaser that wants to get out of a long-term contract. Now, just incidentally, there's a very interesting point that seems to arise all the time that was touched upon both at first instance and in the Court of Appeal in Solid. And you may not know this, it's sort of often obscured by the much more important, perhaps, or significant principle finding. but also the issue of waiver, estoppel and things of that nature in a sale of land context. I'm sure you've all come across a situation where somebody has a right to terminate under Section 32 and an issue arises as to whether there's been some course of conduct or some matter that means that that right has been lost or would be unfair due to the circumstances I'm referring to for the purchaser to rely on that right. And the legal shape that argument takes, of course, is some kind of estoppel or a waiver or something of that nature. Now, there's been a great deal of authority either way on this point. Obviously, estoppel is such a powerful argument that has traditionally been able to sort of go behind statutes and effectively rewrite the law in the way the presiding judge thinks appropriate for the particular facts of a case. So the question was, can it kind of override Section 32, which is on its face completely clear and absolute? It gives a right to terminate right up until settlement. And so therefore, how can that be consistent? Or how can that be applied in accordance with its terms if we allow things like estoppel and waiver? Well, that kind of reasoning is the reasoning that now seems to be accepted in this state, where before it was uncertain. Justice Bongiorno at first instance found that there's no room for things like estoppel and waiver in the context of Section 32. And interestingly, Justice Mandy, who delivered the leading judgment on the appeal, you should look at in the paper that the reason he found not to even touch on the issue is incredibly interesting and deals with questions of affirmation and waiver in a contractual setting, but I won't go into those. But what he did say is there is something to be said for the correctness of the view expressed by the trial judge. So we've now got a absolutely considered and firm opinion from a first instance Supreme Court judge, and we have an indication really from 3 members of the Court of Appeal about which direction we're going to be taking in this state on that particular issue. To move now to misleading and deceptive conduct, the emphasis here is going to be on the interaction between these provisions, these misleading and deceptive conduct provisions that have such a broad application, and the doctrine of caveat emptor, which is, of course, is well known. It's buyer beware. It's the well-known idea of public policy that our laws always endorsed, which is that somebody that's entering into the contract as the buyer has the onus of going through inspecting the property, looking at the law, working out what kind of problems are going to affect their bargain, and if they miss something, then that is on them, and they have no recourse against the vendor generally. Now, of course, there are exceptions to that existed before misleading and deceptive conduct. You've got the basic common law and equitable misrepresentation, which has always existed. It's been somewhat weakened, I suppose, because it never really overruled or constituted a true exception to caveat emptor, because always in the cases where there was what's called misrepresentation by silence, there was very much a half-truth where something that was uttered was so close to saying there's no problem on this front or something of that nature that it really constituted an active misrepresentation in a sense. And so really it's just, there was always weaknesses in that area of the law, and really they never quite overruled or touched upon caveat emptor in a true sense. Of course, fraudulent concealment was always an exception as well. If you put a rug over some rotten floorboards, paint over termite damage, things of that nature, actively try and conceal the problem, then recourse will be available to the purchaser. Also, latent defects in title, legal problems or encumbrances on the title were always something that there was an obligation on the part of the vendor to disclose. And of course, that obligation existed even if the vendor wasn't aware of what the defect in title was. So that was a strict liability kind of thing. Now, how the role that's played by misleading and deceptive conduct, of course, it arises from the words of the statute, and the relevant parts really at the moment I think is still Section 52 and Sections 7, 158 and 159 of the Fair Trading Act. Of course, the New Consumer and Competition Act has taken over the field, and as cases start coming up that were arising after the 1st of January 2011, you'll start to use that statute, but really the law's, in my opinion, identical, of course, and at the moment all the cases coming through are still under the old regime. Now, there's an important qualification to make about what I'm going to say from the outset. Misleading and deceptive conduct is so broad that the Parliament thought it appropriate to limit it in some way so it wouldn't apply in sort of private settings where it was inappropriate. So they've put a a proviso that says you can only sue on this provision if the conduct that's impugned occurs in trade and commerce. So the problem there is a decision of the full federal court in O'Brien and Smologanoff in 1983, back at the start of the Act when it was first being interpreted, that took a very narrow view of that provision and said that somebody that's just selling a block of land or a house that they live in as a private vendor is not acting in trade and commerce, which is somewhat surprising in a sense because, of course, whether or not you're doing it in a business or as part of a business enterprise, somebody that is living in a house and then decides to up and sell it is, in relation to that transaction, certainly engaging in a commercial activity. So, but regardless of that, the full federal court's decision has stood now for a long time and has not really seriously been challenged, and it now represents the law. So what I'm saying applies in all contexts to commercial properties, and of course if it's a private residential dwelling where there's been some kind of commercial activity by the vendor, then you can attack or sue a vendor under the provisions as well. And I think the highest example of that I've seen is in 1998 there was a Supreme Court decision that held that simply demolishing a property and then building a new one and selling it with a view to doing that all as part of a quick commercial transaction, that would be enough to be in trade and commerce, even though the guy was not a professional developer. But either way, none of that's really that relevant because nowadays, of course, every transaction happens through an agent, and an agent will always be acting in trade and commerce, and the representation almost certainly will come through the agent. And so therefore the agent can be sued in damages if there's some kind of misrepresentation, and that's usually the way things are done in the modern era. You just sue the agent for compensation under the Act. Now, how we get to the problem of the interaction between misleading and deceptive conduct and caveat emptor arises, I think, from the definition of conduct. It's misleading and deceptive conduct that is the touchstone of the provision and the thing you're looking for when you're trying to sue under this Act. And that's defined in section 4, subparagraph 2, as to include refraining, otherwise than inadvertently, from doing an act. So, of course, silence can be encompassed by that rather broad definition. And the question is, in conveyancing contexts, what kind of situations will suffice so that silence and standing by while somebody makes a potentially devastating investment, unaware of some kind of problem with the land, when will it be enough to actually elevate that into some kind of actionable status where, you know, it actually gives rise to a cause of action? Well, the first relevant decision on that point is Demagogue and Rumensky, where the full federal court looked at a fairly normal conveyancing transaction. It was a development in Noosa where the developer had a parcel of land that was, you know, up near a beach, a very nice parcel of land that was being, or upon which a block of flats was being constructed, and an agent was taking the buyer or the potential buyer through the property, and a driveway had only been partially constructed at that stage and didn't run all the way down to the main road. And so the prospective buyer says, what's the situation with access? And the agent said something along the lines of, well, look, of course there will be access. The developer will build a driveway up to the road. Now, the problem with that was there was access in a sense. What had happened was the developer, 10 days before, had arranged a kind of Crown grant or Crown licence with the government to allow people that were going to and from the development to traverse Crown land. There was a parcel of Crown land that actually separated the land upon which the development was being built from the road. So it was necessary for the developer to make that arrangement. The problem was, though, that there could only be the way the covenants and the licensing structure worked with the Crown required the licence to be with the body corporate rather than with the potential or the particular lot owners. And without going into the complexities, it turned out there was a great deal of scope for problems in the way it was structured that meant that there could be difficulties in the body corporate actually adhering to its conditions under the licence, and it would require everyone in the block to cooperate in a way that could mean that eventually the licence could have been jeopardised and the access could have been potentially cut off. So long and short, there was some kind of hidden problem with the access, and a question had been asked that went right to the heart of that issue. And whilst an honest answer had been given, in a sense, there was that silence where, you know, the issue, if you like, had been triggered, and the response had been found wanting in that it didn't actually tip this person off as to the potential disaster they were facing by investing with this unknown problem being present. Now, it's really the facts are important, of course, but in one sense, they could also be seen as a kind of half-truth situation that's similar to the old law of misrepresentation. I mean, it's not like there was literally no discussion of the access. There was some question about it, even though it didn't quite get to the heart of the matter. And there was, I think, a potentially misleading answer that didn't give full disclosure. But it's the reasoning of particularly Chief Justice Black that has led to what I see as a massive growth towards cutting back caveat emptor as a result of this decision. And what Chief Justice Black says is this: although mere silence is a convenient way of describing some fact situations, there is in truth no such thing as mere silence, because the significance of silence always falls to be considered in the context in which it occurs. That context may or may not include facts giving rise to a reasonable expectation in the circumstances of the case that if particular matters exist, they will be disclosed. Now, those last words there have been, I think, latched upon by many a judge and many a plaintiff to try and expand these principles at a dramatic rate to allow purchasers and other sort of victims of misrepresentation to sue under these provisions in highly, I suppose you can call, unsettling circumstances if you're a purist that believes in things like caveat emptor and things like that. The problem is the phrase reasonable expectation. If almost in any circumstance where somebody is offering a property for sale, or you can even treat it more broadly as a general, think of any contractual context where you're about to enter into a bargain with somebody else, they're the dominant party that knows the situation well, you're the guy that's coming in without much knowledge of the subject matter. Quite often there'll be situations that the dominant party, the knowledgeable party, knows about that he will not want to share with the weaker party that's ignorant. And of course, throughout the entire history of law and commerce, practically, it's been permissible for the dominant party not to disclose and to, subject to the limited exceptions I've discussed, to keep the knowledge in his pocket and to do a bargain that allows the weaker party to fall victim to their own failure to do the proper checks. The reasonable expectation test seems to cut that back. It raises this very slippery point about, or question about, when it'll be reasonable for somebody to just stand idly by and not go further and make a disclosure that allows the innocent party to potentially preserve their interests in the transaction. Now, probably the classic caveat emptor example that all property lawyers are familiar with is termite cases. It's been held that if there's extensive termite damage to land, then it will not be an excuse for the purchaser, upon discovering that, to get out of the contract or sue for damages, short of fraudulent concealment or some exception. Even the most horrific defects in quality do not give rise to an action. So how does the law of misleading and deceptive conduct relate to a classic termite case? We have a fairly unclear answer, but some kind of indication of how it might, from a decision in 2007 of the Supreme Court, Walker and another, and Masilamani, where Justice Kavanagh considered a case where a woman had gone through a property. She supposedly had some kind of aversion to insects or a fear of insects, and asked the agent whether there was any kind of white ants or spiders or anything like that, or bugs. And the agent was said to have replied, "This house is perfect." Now, unfortunately for our exposition of the law, our understanding of these legal issues, Justice Kavanagh found that this person was not a credible witness and believed that, in fact, the agent had made no such representation. So therefore the case failed basically on its facts, but Justice Kavanagh did consider what the position would be in terms of purely misleading, deceptive conduct. What if this agent had simply not said anything about the problem with knowledge of it, or even worse, given of course that misleading and deceptive conduct is a strict liability cause of action, if you like, and doesn't require knowledge on the part of the representor, is it possible, if there's some kind of defect in the property, that the vendor could have some kind of higher liability that means that even if he's not quite sure about whether a defect exists or not, or its extent, he still is responsible if it turns out that he has not disclosed it? Well, Justice Kavanagh deals with that and says, in the present case, I would not have been satisfied on the evidence that the facts gave rise to a reasonable expectation that Miss Burge Ripley would disclose the termite damage. Among other things, I would not have been so satisfied because, according to evidence given by both Mr Walker and Ms Burge, which I've accepted, Ms Burge had no knowledge of any prior termite infestation or damage. Now, of course, that's entirely orthodox and a reasonable holding, I think, in the circumstances. But the implication is that if the person had known of the termite damage, then there'd be a very serious question in His Honour's mind about whether the person would have been liable, which is quite an extraordinary finding. So it seems to indicate that if you have knowledge of some potentially disastrous quality defect and you do not disclose it, there's nowadays a serious question of fact about whether there's been some kind of misleading and deceptive conduct, not because you've so much done anything that's actively deceptive, but because there's a reasonable expectation on the part of the purchaser that you would disclose something like that if you had knowledge of it. That, of course, goes back to the Demagogue case and Chief Justice Black. Now, and a good example as well comes from, this is just how far we've come now in the modern era, 2010, a decision of Deputy President Aird at VCAT called Sri Law, which is in the paper. In that case, there was purely a legal, what you might call a sort of planning defect or something that didn't even relate to quality at all, where under legislation, premises had to have a disabled lift installed, and this was not disclosed to the tenant, who was liable under the lease to fit out the property in accordance with law. So that's an incredible finding. Deputy President Aird there said that because there's some kind of onerous, I suppose you could call it planning restriction imposed by law that is going to put the tenant to expense, that somehow, even though there was nothing even close to a half-truth, nothing at all, there was simply a failure to point this out on the part of the landlord, who said nothing about the fact that you're going to have to spend a lot of money, tenant, to fit out this premises with a disabled lift. The mere failure to say that was enough to constitute misleading and deceptive conduct in the mind of a deputy president and a county court judge of VCAT. Now, the final decision to wrap all that up, I think, has to be BMW Miller and Associates and BMW, which is a recent case of the High Court from late 2010, which really considered the whole trend, not so much in a property law context, but in the context of this general idea of, do you have to volunteer information in a commercial context when you know something that they would really want to know but don't, and you want to keep it to yourself in order to increase your chances of getting a good deal and minimise theirs. An incredibly fundamental point, obviously, for all commercial lawyers and businessmen generally. The specific facts there was, probably most of you are familiar with the type of transaction where a lender will finance an insurance premium for some kind of business, and always those premiums or the policies that are financed are able to be cancelled if there's some kind of breach in the repayments, and then the insurance company gets the premium themselves. In this case, there was a policy that was not able to be cancelled in that way. So effectively, money was advanced on the strength of something that was entirely worthless if there was a default by the borrower. And the broker was the one that was sued there for misleading and deceptive conduct. It was said that he really knew exactly how important it was to make sure the policy could be cancelled and the premium taken in by the lender. And the broker simply failed to disclose that fact and treated the situation as though it was entirely normal. The lender had asked for information about the policy to be sent off by the broker, describing its attributes, and this incredibly fundamental point had not been made in the paperwork that was sent. Now, the High Court, whatever you could say about the paperwork and whether there was any kind of half-truth, in my submission, there was no half-truth here at all. It was simply a case of an omission in circumstances where omission was held or argued to be incredibly unfair. The High Court rejected this theory and says, as a general proposition, Section 52 does not require a party to commercial negotiations to volunteer information which will be of assistance to the decision-making of the other party. A fortiori, it does not impose on a party an obligation to volunteer information in order to avoid the consequences of the careless disregard for its own interests of another party of equal bargaining power and competence. So I think that really does hose the whole issue down. Perhaps before we could have arguments being put based on demagogue, that a vendor of land or a landlord of in a leasing situation that did not disclose something of huge importance would be in trouble, because there was a reasonable expectation on the part of the tenant/purchaser that that would be disclosed. What the High Court is saying is, no, that doesn't matter. As long as it's something that can be ascertained by reasonable efforts by the tenant or purchaser, then they have an obligation, of course, to do what has been done throughout time, really, and to go through and conduct their own due diligence on the deal or on the property and work out for themselves whether they wish to proceed, which I would suggest is the orthodox view and is now going to reduce the effectiveness of some of these more radical, misleading and deceptive conduct arguments. Now, I'll leave that topic there, and in terms of time, I think we're rapidly running out. So there's some other stuff there in the paper. Owners' corporations, there's an interesting point about standing and jurisdiction, which I recommend that you read if you're doing any litigation on that front. There's some material in there about stays if you're doing anything on behalf of a borrower that's in trouble under a mortgage, which is very useful. But other than that, I think we'll have to bring it to an end. Any questions?
Just be careful what I say here, but in Demagogue they waited for 2 years for a decision on that case. Demagogue drew his breath and wrote a letter of complaint to the Chief Justice. They got a decision the next day. And that's what happened with it, was because it was holding up the whole development. There was about 10 units in that development.
It's an interesting point, because Justice Gumow, who of course now is on the High Court, if you read his judgment, Chief Justice Black, of course, throws out this line about reasonable expectation, and that's been latched onto by litigants to build these arguments I'm discussing. Justice Gumow just says that misleading and deceptive conduct is to be determined based on the words misleading and deceptive conduct, and just leaves it with that elliptical sort of obscure passage. So I can see what you're saying. There doesn't seem to have been a great deal of thought to kind of refine some of these points and think of the longer term consequences, perhaps. Anything else? Thanks very much.